Good evening. This is the January 29th, 2025 meeting of the Newcastle Zoning Board of Appeals. Mr. Secretary, the first case.
Liv Schultz.
Yes.
Yes,
Good evening.
Can you tell us your name and what it is that you seek?
I didn't hear you.
Can you tell us your name for the record and what it is that you seek?
My wife, I'm retired, I was a lawyer, but it's my wife's property, let her speak for herself.
I forgot it was my property. You can speak for me, with me.
Elizabeth Harris, Liv Schultz,
And, yeah.
and our architect is on the screen, Niall Kane. And I thought Niall would explain as, I don't know your process, but,
Just to get it into the record, whoever wants to give the explanations.
okay.
fine.
So part of it is a question about the property line setback, which does not involve the work that Niall's going to do for us. Yeah,
can you hear me?
yes.
Yep.
Hi.
Okay, I can share my screen, it's just, let me share my screen here, I had, sharing it already, no. Okay, so anyway, I'm Niall Kane, I'm the architect for Betsy and Lowell Liv Schultz, who just introduced themselves there. This issue, you were asked for a variance for a non-conforming shed, and this came up because we're proposing a accessory dwelling on their existing detached garage, and it was brought up after many years that apparently this little shed is non-conforming and needs a variance. And as far as we know, the shed has been there for many, many years, certainly pre-1973. And the issue has never come up after several alterations and additions and swimming pool and various other things. But anyway, this is the offending shed. Photographs.
Niall, let me add to your presentation. We've gotten, I think, 7 or 8 or 9 COs granted to us for building onto the house, which we bought in '73. That little shed was there before we in fact bought the property. And if you look at I know if it's in your materials, the distance we infringe is extraordinarily small. Now, I would have torn down the shed, except we rebuilt it just as it was about 6 months ago, not having any idea that we were infringing in any context. So that's the kind of the story behind the shed.
That's and the use of the shed is for what? What do you use the shed for?
We use it for nothing. It's actually just for its beauty.
So it's empty?
It's
Well,
empty.
it's empty. Years ago, it held outdoor furniture, I mean, it was on the property when we bought it. And
And if you look from any other person's property adjacent to our own, you don't see the shed.
No, Steve, okay. I have 2 questions. Number 1, if there's nothing in it, why do you wanna leave it there? And number 2, it's listed on our application as a portable shed. Can you tell us why it can't be moved to a place on the property that will not infringe on the front side or
I apologize, I'm having some difficulty hearing.
he said it was why not move it? It's a portable shed.
Can you give us, if you give us a good reason why you can't move it,
It's on a
we'll-
slab, it's on a
It's
slab
on a
of
slab, it's built on a
concrete.
slab.
Okay.
I think we spent about $5,000 or $6,000 rebuilding it.
Okay.
And
That looks nice.
while it's for its beauty, we also can use it to store things along the way. We have pool furniture and so forth and so on.
So why it says portable, it isn't really portable, so
It's cute, it's cute
Yeah, it's just-
though.
but it's been there for so many years. It seems sort of like a pre-existing condition. And you can see on my site plan here, the setback lines and the shed, which is indeed outside of those setback lines, but again has been for pre-1973. The house was built in 1930.
And
The original house.
there's never been a complaint to my knowledge
Okay.
about the shed. So I'd ask this question of you kind of, why would you want us to move or take it down or do anything
Well,
else?
we don't want you to do that if you have a good reason to leave it there. Our job is to try to minimize any variances that we approve. Our job is to try to maintain the law as it's written. When we need to give a variance, our job is to try to make it as minimal as possible, unless you have good reason for it. I mean, this shed application is nothing unusual for us. We see them all the time, and we understand the fact that it's been there a while and it has never affected anybody negatively. That's not a problem. And for the record, if you have use for it and there's no other place on your property that's suitable for it, that's a good thing. That's a plus for us.
Can I say one other thing? I think
Sure.
Tom's done a great job. He's worked with us and he said, look, you're going to have to get a variance and that's necessary. But I was thinking, why doesn't a board like this give him the discretion in a matter like this? One that doesn't require a great deal of thinking. Why wouldn't it give him the discretion to be able to make an application directly to you so that we can resolve this without going through this whole process?
Because we have a zoning code that has to be followed. As an attorney, you should know that. And it's just the way, if somebody wants to change the law and give Tom more or less power, so be it. But the way it stands right now, we have been given the power and authority to review any zoning necessary variances and rule on them how we see fit, hopefully for the benefit of the applicant as much as possible. We're not here to make trouble for anybody,
Right.
believe me.
Anyway, anything else you'd like to ask us?
No, I'm gonna ask my colleagues if anybody has any questions about this.
No questions.
Anybody okay with that?
I would interject one, which is always dangerous. He's getting nervous right now. We've done work on our house on several occasions and all of them went through without any challenge, right? But I mean, there were several, not one. Yeah, because there've been several things and there was never any issue about the cute little yellow building, so.
Okay,
Alright.
no other questions? Then I'll move we close the public hearing.
I second the motion.
Chairman Giordino.
Aye.
Mike Nolan.
Aye.
Ron Genzeg.
Aye.
Warren Gottlieb. Kathleen Darazan.
Okay, I'm gonna make a motion that we approve the application of the Elizabeth Lifschultz for a requested side yard variance of 16 feet to legalize an existing shed.
Excuse me, Tony, did we ask for public comment?
Actually, we didn't, you're right, thank you.
That was Tom
Before
Clark.
we close it, thank you, Tom. Is there anybody in the audience who would like to address this application? Don't be a wise guy. Anybody online or
No, you said no hands raised.
no hands are raised? Okay, so we're good. We'll go back to closing the public hearing, we can just leave that as it is, no problem. Sorry about that. Okay, so I'll make the motion that we approve the application of Elizabeth Lifschultz for the legalization of an existing shed that needs a 16-foot side yard variance for the following reasons. This shed has been on the property for many years without any detriment to the neighborhood. There have been no neighbors who have complained or commented on the location of the shed. There is really no other place on the property convenient or suitable for the installation of the shed. Where it is the best possible place. The granting of the variance would not create an undesirable change to the character of the neighborhood. The benefits sought cannot be achieved by any other method than a variance. This is not a substantial variance in this particular instance. There will be no adverse effect on the physical environment or conditions in the neighborhood. It is in a way a self-created hardship, but in this case, the benefit to the homeowner will far outweigh any perceived detriment to the neighborhood or to the town. Do we need any surveys on this, Tom, or do you need the measurements? How are we gonna work that, since it's already there?
The survey has been submitted.
It has been submitted. We have a survey on file, therefore, for these reasons, we grant the variance.
I second the motion.
Chairman Giordina.
Aye.
Mike Nolan.
Aye.
Ron Genzeg.
Aye.
Warren Gottlieb.
Aye.
Kathleen Darazan.
Hi.
You have your variance, good luck.
Thank you all very much. And thank you for all the work you do on behalf of the community.
You're welcome.
11.
Anybody here for 11? Oh, it's on, just online?
Oh, I think he's muted. Mark, there.
Oh, here you go. Hi, everyone. Can you hear me?
Yes. Now we can.
Okay, sorry. I thought I unmuted myself, but I didn't click it. Hello, everyone. My name is Marco Manjo. I'm the architect representing 2H Cross. We're applying for a variance for a new outdoor patio at the rear of the building and an open roof structure. We made some slight adjustments in the initial submission, so the variance setback is actually smaller. Essentially, we're proposing, let me share my screen. Can everyone see my screen?
Yes.
So, this is the patio we're proposing. We're essentially a slab on grade with some flagstone. So we're approximately 14.9 feet over the setback, which is a 60-foot rear setback. And then the roof structure itself with the columns is approximately 1.5 feet. Now, there's a portion of the existing building here in the gray, which is already over the setback. And we're just shy of aligning with it. Just to give you a 3D view, the patio is essentially slab on grade, and then the structure is essentially just an open roof structure to allow a little shaded area, and just to give the family a little bit more outdoor space and to enjoy their rear yard.
So you say that the patio is 14.9 feet requested variance rather than 16?
Yeah, so we adjusted the patio, and we adjusted the roof structure. So as you can see here, the patio is 45.1 feet from the rear yard. And the roof itself is 1.5 feet over the setback. It's quite a large setback in my personal opinion. In most municipalities that I work in, I actually don't think I've ever seen a 60-foot rear yard setback. It's kind of cumbersome in this situation. It takes a lot of space away from their rear yard. I don't know if it's just the placement of the building. I mean, it's a pretty large, nice property, but to have that large setback, I'm used to seeing more like 30 feet and 40 feet. I know this is the code, but it just seems a little much. Just my opinion.
Setbacks, we don't determine the setbacks, that's determined by the town board, we just enforce them.
Of course.
So now a question on that roof structure. My record here says that you're requesting a 4-foot variance on the roof structure, and you just said it was only, let me say 2-point-something feet?
1.5, you said.
1.5?
Yeah, so we actually
How did that
made
happen?
some modifications. So we shrank it. So it's only, you see my foundation plan, the footings only come out 14 feet off the back of the house. It was much larger initially. So we shrank the roof. So when we initially got the denial letter, the patio and the roof structure was larger. And then when we submitted it back to the zoning board, we made the modifications. So the plans you have in front of you and the plans I'm presenting should be the updated plans with the new roof and new patio.
Okay, alright. Mike, I have a question. Since the numbers have been changed, but not made bigger, made smaller, can we still proceed without having to?
Yeah, because,
update the paperwork,
yeah, because the variance is less.
unless, okay, yeah, I don't wanna do something that
Then, yeah, we can proceed.
can come back to us later, be a problem. Okay, so that's good. I have no other questions, anybody on the board have a question?
I just have a question. You said, is it correct that one part of that house that juts out is existing non-conforming?
Yeah. If you look at the screen here, I got 1.9
Okay,
where the house is over the setback.
okay, thank you.
Mm-hmm.
Anybody else? Anybody in the audience would like to address this application, pro or con? No, anybody, any hands raised?
No hands are raised.
No hands are raised. Okay, I'll move we close the public hearing.
Second the motion.
Chairman Giordina.
Aye.
Mike Nolan.
Aye.
Ron Genzeg.
Aye.
Warren Gottlieb.
Aye.
Kathleen Darazan.
Aye.
No.
You wanna take it?
I'll take it, sure.
Okay, this is an application for two variances, at 2 Hayes Cross Road, property Jason and Michelle Levin. Basically, this is an application to construct a patio, with a covered roof, in the rear of the property, and that's what's, being sought. And they need two rear setback, variances, one for the patio and one for the roof structure. The application itself, the original application sought a requested variance of 16 feet on the rear yard setback for the patio, and I think originally 4 feet for the roof structure, rear yard setback variance. But the applicant, prior to coming today, has actually reduced the size of the variances sought in each of these instances. For the patio, they're seeking a requested variance of 14.9 feet. We got that correct? And
Yeah.
for the roof structure, the requested variance is 1.5 feet. I move that we approve the requested variances for the following reasons. First, the variances will not create an undesirable change to the character of the neighborhood. The setbacks are quite large, and the applicant has made an effort to minimize the size of the variance. Second, the benefit really can't be sought, can't be achieved by some other method. They're looking to get a little bit more enjoyment out of their backyard, and the way that they're looking to do that, there's really no other method. Again, as I mentioned earlier, the requested variances are really not substantial, and in both instances, the applicant has made an additional effort to reduce the size of them. I don't think there'll be any adverse effect on the physical environment or conditions of the neighborhood. There's been nothing in the record to suggest that. The alleged difficulty, I guess you could say, is self-created hardship, but this factor is definitely outweighed by the benefit to the applicant, and certainly to the community. It just seems to be an addition that fits in with the character of the neighborhood. Tom, what do you need from this applicant?
I will need a final survey, please.
Okay, a final survey and 6 months to start and a year to finish?
Yes, sir.
Okay,
Before we go any further, if you don't mind,
sure.
I'd like to make a little addendum to your
Sure.
motion. And you don't have to do it if you don't want to.
Okay, no, no.
But instead of 14.9, I'd like to give them 15, because you never know.
Okay,
If they're a little off, they have to come back to us.
okay,
And instead of 1.5, I'd like to give them 2,
okay.
again, to prevent them having to come back at a later date for some little miscalculation in the measurement.
Okay, absolutely. Okay, so the motion will be slightly amended to provide a rear yard variance setback variance for the patio for 15 feet, correct?
Yep.
Yeah.
And for the roof structure, we'll make it a variance of 2 feet. So give you a little wiggle room there.
I was gonna say that myself.
Okay, thank you.
I'll second
Okay,
that
that's-
motion.
Okay.
Chairman Giordina.
Aye.
Mike Nolan.
Aye.
Ron Genzeg.
Aye.
Warren Gottlieb.
Aye.
Kathleen Darazan.
Aye.
You have your variance, good luck.
Thank you so much. Have a good evening.
You're welcome. Okay, the next application is Bao and Son. It's a returning application. For the record, I'm recused from this application, and Mr. Nolan will be taking the lead. You can stay here. Go to, no, you're not supposed to. Go to it.
Okay, just for the record, we are opening up the public hearing on this case,
Reopen.
reopening.
Good evening, Whitney Singleton from the firm of Singleton, Davis and Singleton on behalf of the property owner applicants. I can go through the whole history of this. It's been a while since we've been before your board, but I don't know that it's necessary. I presume that you've read the memos from the building inspector, the town engineer, and from your council. Essentially, we can't get to this property without using the driveway that we've always used. The house burned down. They're looking to rebuild, albeit 21 years later. They're looking to rebuild and there's no other way to gain access. I personally think, and I've stated in my papers, that it's a pre-existing nonconformity and doesn't need a variance under either state law or under your town code, but I also stated to your board that however we get there is fine. If you'd rather issue a 280A variance, we're fine with that. And I've had an opportunity to look at your draft resolution. I think the conditions in it are very reasonable. So the only other thing that's come up since then is that there was a letter from a neighbor. The letter from the neighbor, I'll kind of limit my commentary on it, but there should be no concern to that neighbor. The improvements that need to be made to comply with the state requirements for a shared driveway, a shared emergency access driveway, have a minimum width, which the road already meets substantially, which Brock's Rocks Road already meets, and has to have turnouts and turnarounds for fire apparatus trucks. That is a condition of your approval. Those are not required to be installed anywhere near the neighbor that wrote the letter's property. They're down with frontage on Shingle House Road, and they access, as he said in his letter, only just a couple feet in from the road. The turnouts are supposed to be not less than every 500 feet. So that's gonna be well past his driveway. Our client's property is at 430 feet. So it's probably gonna be incorporated into the turnaround for fire apparatus. So it should have no impact on the neighbor. We will certainly not be going on anyone else's property. The only thing that might be impacted is the right of way which they all share. And I think it's gonna be nowhere near that particular property owner's or anyone else's.
Right, I think we understand that the right of way is the right of way, and we're not necessarily privy to what is in the right of way, or so at this point in time with the resolution. Mike, do you have anything that you wanna add to that?
So basically what we're saying is to the extent that any disturbance to trees that exist in the right of way is beyond the purview of the objective of an adjoining landowner, and to the extent that the disturbance would affect the property of an adjoining landowner, that there are restrictions that you would have to comply with as part of the application, the permit process anyway. So both, I'm just saying, to the extent that hypothetically there was disturbance to trees on the neighboring properties, the neighbor's property, you would have obligations under the statutes and the ordinances to replace.
That's not gonna happen though.
Right,
It's a 40-foot right of way and the required road width is 12 feet.
Right. The only thing I did wanna clarify though is I'm hesitant to, have the board grant a variance that is not, clearly requested. I know you said you would accept, even though you initiated this as an interpretation of the building inspector. I do wanna make it clear that, at this point, given where we've come to over the last few months, that the applicant is now requesting a 280A variance.
Correct.
Okay.
Okay.
He's trying to put me in a corner.
Just trying to make sure that we're covered.
That's okay.
Just
My
trying to make
only
sure.
other objection
Yes,
to your draft resolution, and I didn't even bother to share this with Mike. And it doesn't matter, so long as the vote goes the way the vote needs to go. It's kind of hard for me to accept that this is a self-created hardship, the fifth element. Their house burned down, and there's no other way to get access. I mean, it's kind of not self-created, but they did buy the property
Right.
subsequent to the fire, and you are charged with constructive knowledge of all the zoning requirements. I get that.
it's
Just sticks in my
possibly
craw.
a subjective concern or interpretation, but at this point in time, I think that's probably apropos of what we need to be able to do to get,
It's fine.
Yeah.
to move this forward.
Yeah, and I think the constructive knowledge is really where that, that portion of the resolution came from.
Okay. Does any of the board members have any comment? Any members of the public have their hand up, or anyone have anything to add to this?
No hands raised
Is that Bob Seoli up there?
That is.
Mr. Seoli was very, very helpful.
Thank you, Whitney.
Then I make a motion that we close the public hearing.
Second the motion.
Chairman Nolan,
Aye.
Ron Genzeg,
Aye.
Warren Gottlieb,
Aye.
Kathleen Darazan.
Aye.
Thank you very much.
Well, we
Appreciate
have,
it.
do we have to make a resolution?
That was on the public hearing, sorry.
So I would make a motion that we grant a and I think we'll call this a 280A variance, grant a 280A variance to Zebao, and pardon my pronunciation, I'm not certain, Yuja Sun of 56 Shingle House Road for the construction of her home and the associated resolution that is there a number or a name of this resolution?
There is, I don't know it off the top of my head.
Well, I would say then the resolution that we have that's dated Wednesday, January 29th, 2025, and all of the statements made within the resolution is what the board is voting on. There will be with this resolution, there will be no undesirable change in the character of the neighborhood, no detriment to nearby properties as a result of the granting of the variance. Is potential that the variance will improve the Brox Road and portion of the driveway. There is no other method than the granting of the variance to achieve the desired benefits except to improve the street in question to town road standards. Such improvements are not feasible due to current impediments and are not necessary for the addition of a single family home on Shingle House Road. The variance is substantial, but we will be mitigated by the applicant's compliance with the conditions set forth below and above. The requested variance will not have an adverse effect upon the physical or environmental conditions of the neighborhood, and the addition of a single family home will not have any negative environmental impacts. And finally, the alleged difficulty is a self-created hardship. However, the applicants have made reasonable efforts to minimize potential impacts, and the benefit to the applicants outweighs any perceived detriment to the town or the neighborhood.
Yes,
Mike?
yes, I would recommend that we read the resolution in full into the record, although I know from now therefore be it, I believe we should read that into the record, so
Okay, sure, we'll start from the very beginning.
yeah, you know what, we might as well.
Okay. This is the details of said resolution of Wednesday, January 29th. Whereas Zebao and Yuja Sun, the applicants at 56 Shingle House Road, Millwood, the property submitted an application to the zoning board of appeals for the town of Newcastle for an interpretation from the board regarding the necessity of a variance under section 280A of the New York Town Law for a proposed new single-family residence with frontage on an unimproved map street on the property in an R1A zoning district located on the west side of Shingle House Road, said property being known and designated on the tax maps of Newcastle as section 80.16, block 1, lot 7. And whereas the applicant's counsel, Whitney Singleton Esquire, submitted the following applications and materials associated with the proposed action. On the adjournment request from Whitney Singleton Esquire to Jackie Bertram, ZBA Secretary, dated December 17, 2024, received December 17, 2024. Letter from Yuja's son, property owner, to the Zoning Board of Appeals dated November 19, 2024, received November 22nd, 2024. Adjournment request from Whitney Singleton Esquire to Jackie Bertram, ZBA Secretary, dated November 19th, 2024, received November 19th, 2024. Cover letter from Whitney Singleton Esquire, Singleton, Davis and Singleton PLLC to the Zoning Board of Appeals, dated July 26, 2024, received July 29th, 2024. Exhibit A, McKinney's Town Law 280, is that 280A?
Should be 280A.
Permits for buildings not on improved map streets. Exhibit B, Westchester County GIS map dated July 26, 2024, Westchester County GIS map dated July 25th, 2024, and additional Westchester County GIS map dated July 25th, 2024. Exhibit C, cover letter from Ralph Mastromonaco, PE, PC, to the Zoning Board of Appeals dated July 26, 2024. Ground profile from Shingle House Road to house site prepared by Ralph Mastromonaco, PE, PC. The application to the Zoning Board of Appeals dated July 26, 2024. Notice of denial prepared by Thomas DePaul III, dated July 29, 2024. Zoning Board of Appeals applicant acknowledgement dated July 26, 2024. Town of Newcastle escrow account set up from form and copy of checks dated August 20th, 2024. Coverage calculations worksheet dated August 20th, 2024. Topographic survey of property prepared for Ellen Son and Marcel Bao, prepared by Geologic Land Surveying PLLC, dated September 15, 2023. Plan title, site plan prepared for Whale Axleway 56 Shingle House Road, sheet 1 of 1, prepared by Ralph Mastromonaco, PEPC Consulting Engineers, dated November 24th, 2023. Whereas during the course of the zoning board's review of the application, the zoning board has also received and considered the following correspondence from town staff, consultants, and government entities and officials as follows. Memorandum from Thomas DePaul III, Building Inspector, to the Zoning Board of Appeals, dated and received January 23rd, 2025. Memorandum from Millwood Fire Chief Greg Santone, dated and received October 24th, 2024. Memorandum from Town Engineer Robert Cioli, PE, to the Zoning Board of Appeals, dated and received September 24th, 2024. Memorandum from Deputy Town Engineer Robert J. Cioli, PE, to the Zoning Board of Appeals, dated and received January 24th, 2025. Whereas on September 25th, 2024, a duly advertised public hearing was held in this matter and all members of the public were given an opportunity to speak at the meeting. And whereas the public hearing on said application was adjourned to October 30th, 2024 zoning board meeting. Whereas the public hearing on said application was further adjourned to November 20th, 2024 zoning board meeting. Whereas the public hearing on said application was further adjourned to the December 18th, 2024 zoning board meeting. Whereas the public hearing on said application was further adjourned to the January 29th, 2025 zoning board meeting. Whereas the applicant was directed to speak with town staff and address resolution of the matter, including emergency access issues regarding driveway, widening, and water line sufficiency as discussed in staff memoranda. And whereas the applicant's attorney worked with the town council in an attempt to come to a resolution on this matter. And whereas the applicant agrees to make all necessary roadway improvements as requested in the deputy town engineer memorandum dated January 24th, 2025. Whereas the public hearing was closed by unanimous vote of the zoning board of appeals on, I guess that would be January 29th, 2025. Is that, am I going?
I'm sorry,
It's in there.
Mike, yeah, the next,
Do we haven't,
I think this is the final version, maybe
This is the last version I got today.
Just continued.
You want me to read it in?
January
Sure.
29th.
Whereas the public hearing was subsequently closed by unanimous vote of the zoning board of appeals on January 29th, 2025, and the zoning board of appeals considered the draft resolution prepared by the zoning department and the town attorney approving the requested variance. Whereas the proposed action, type 2 action, you want me to keep reading? I don't mind reading. I'll give you a break.
I'm really enjoying reading though.
Okay, go ahead.
The proposed action is considered a type 2 action pursuant to 6 NYCRR 617.5C parentheses 11 close parentheses concerning the construction of a single family residence on an approved lot requiring no further action pursuant to the New York State Quality Review Act, SECRA. And whereas the applicants revised the plans, provided additional materials, and worked with the town engineer, deputy town engineer, and town building inspector to address concerns raised by the Chappaqua Fire Department, town engineer, and deputy town engineer, and whereas pursuant to the New York Town Law, Section 280A, open parentheses 3 close parentheses B close open close parentheses, the zoning board of appeals is authorized to grant an area variance from the requirement for a building to have frontage on a street or highway giving access to the proposed structure that has been duly placed on the official town map pursuant to the area variance standards set forth in New York Town Law, Section 267-B, with reasonable conditions to protect any future street or highway layout. And whereas the zoning board of appeals finds, and I'll go through this again.
Yeah, please.
Okay, finds that there will be no undesirable change in the character of the neighborhood and no detriment to nearby properties as a result of the granting of the variance. To the contrary, the granting of the variance will improve Rock Road and portion of driveway by designing and building the proposed improvements as required under the Section 511 of the 2020 Fire Code of New York State, which will provide for safe access of fire apparatus and emergency services to all properties in and along Brockshaw Road from Shingle House Road. There is no other method other than granting the variance to achieve the desired benefits except to improve the street in question to the town road standards. Such improvements are not feasible due to the current impediments and are not necessary for the addition of a single family home on Shingle House Road. The variance is substantial but will be mitigated by the applicant's compliance with the conditions set forth below. The requested variance will not have adverse effect on the physical or environmental conditions of the neighborhood, and the addition of a single family home will not have any negative environmental impacts. The alleged difficulty is a self-created hardship. However, the applicants have made reasonable efforts to minimize potential impacts, and the benefit to the applicants outweighs any perceived detriment to the town or neighborhood. Now therefore be it resolved that the applicant made by Zay Bao and Yuja Sun, 56 Shingle House Road, Millwood, New York, 10549, to the zoning board of appeals of the town of Newcastle for a variance for a proposed new residence with frontage on an unimproved map street pursuant to Section 280A of the New York Town Law on property located in an R1A zoning district located on the west side of Shingle House Road, said property being known as and designated on the tax maps of Newcastle as Section 80.16 Block 1 Lot 7, and the same is hereby granted with the following conditions. Applicants shall pay all outstanding town invoices prior to the issuance of a building permit. 2, the applicant shall have 6 months to start construction and 12 months to complete. And 3, the applicant shall improve Rock Road and a portion of the driveway as required by Section 511 of the 2020 Code of New York State to the satisfaction of the town engineer. Applicants must file an as-built survey upon completion of the new single-family residence. Okay,
You have the general conditions?
yeah.
Okay.
General conditions, the approval of any variance is granted by the zoning board in accordance with and subject to those facts shown on the plan submitted and applicable as amended on or prior to this hearing as in hereinabove recited or set forth. 2, as approval of the variance by the zoning board is limited to the specific variance requested, but only to the extent such approval is granted herein and subject to those conditions, if any, upon which such approval was conditioned, which are herein set forth. 3, the board gives no approval of any building plans, including without limitation, the accuracy and structural integrity thereof of the applicant, but same have been submitted to the board solely for informational and verification purposes relative to any variances being requested. 4, the building permit as well as any of the necessary permits must be obtained within a reasonable period of time following the filing of this decision and prior to any undertaking of the construction contemplated in this decision. To the extent any variance granted herein is subject to any conditions, the building department shall not be obligated to issue any necessary permits where any such condition imposed should, in the sole judgment of the building department, be first complied with as contemplated hereunder. Occupancy will not be made until and unless a certificate of occupancy is issued by the building department of the town of Newcastle which legally permits such occupancy.
Thank you, Mike. I'm sorry to have done that to you, but I guess as the chair, you know, we had to make you work for work for the title.
And you improved as you went along.
I know, I was really going faster there yet, so anyone, we have to second that motion?
Second.
Chairman Nolan,
Aye, yes.
Ron Genzeg,
Yes.
Lauren Gottlieb,
Aye.
Kathleen Darazan.
Aye.
Thank you, I didn't think I'd take up so much of your time. Thank you for everybody.
Thank you, good night, everyone.
Good night,
I
Bob.
was, and I'm like,
Good job, Mike. Glad I
Watch
didn't
out.
have to do it.
I got it.
Okay. We need to approve the December 18th, 2024 meeting minutes. I move we approve them.
I second the motion.
Chairman Giordina,
Aye.
Mike Nolan,
Aye.
Ron Genzeg,
Aye.
Lauren Gottlieb,
Aye.
Kathleen Darazan.
Aye.
Adjournment's in order. I move we adjourn.
And I second that motion.